Well, Lafayette County school teacher is facing accusations of enticement of a child to meet for sexual purposes. Deputies and the Mississippi Bureau of Investigation filed an affidavit detailing that allegation against Molly Ray today. Now, since she's a teacher, a probable cause hearing has to be held to see if there's enough evidence for an arrest. Quentin Smith speaks with an attorney who explains the process of a probable cause hearing. He joins us live in the studio with more. Hey, Quentin.
Hey, Scott, a probable cause hearing is one of the pre-trial stages of a criminal case. Now, we usually hear about a probable cause hearing whenever a teacher or law enforcement is in trouble with the law. Now, the hearings are held to determine if there is enough evidence for charges to be filed against the suspect.
A probable cause hearing is required when you're going to arrest an officer or a teacher. You have to file an affidavit, and then you have to submit that to the court, and then you have to have a hearing to show the evidence that you have to determine whether or not there's sufficient probable cause to have the officer or teacher arrested.
WCBI legal expert Jeff Hosford says the purpose of the hearing is solely to determine whether there's enough evidence to warrant charges.
What it prevents is that kind of situation where there's got to be some proof in order to actually be able to charge the person with a crime.
There have been a few of these cases in North Mississippi in the past couple of years. This is video from a probable cause hearing in Calhoun County, where two educators were accused of not reporting an alleged sex crime. Now, if the judge rules there is enough evidence in the probable cause hearing, the case will then be sent to a superior court.
The person will get picked up, he'll be charged, and then he's entitled to the same rights as any other defendant. And obviously, if it's a felony, the real charges don't come until you actually get indicted by a grand jury. You're charged with the crime of a felony, but you're not indicted on a felony until the grand jury determines there's sufficient evidence.
Circuit court judges typically preside over the hearings. And although a probable cause hearing is in the early stages of a criminal case, similar to a preliminary hearing, Hosford says the two hearings differ.
They would get that hearing after they were arrested. So if there was probable cause, the judge would say there's probable cause to arrest them, go arrest them, and then they would be entitled to another hearing to determine whether or not there was sufficient evidence to hold them.
Hosford says a judge can also set bond amounts during a probable cause hearing as well. A date for Ray's hearing has not yet been set.